Thank you for joining this episode of our webinar series on best practices in eDiscovery. Today's session is focused on the fundamentals of eDiscovery. We've been in the eDiscovery business for over 16 years. During that time, there's been significant growth in the application of eDiscovery across practice areas, due primarily to digital transformation, and then accelerated by the pandemic. We've also seen several paralegals and lawyers leverage eDiscovery to advance their careers and practices. My name is Jeff Fugit. I'm the Chief Revenue Officer for Lexbe, and I'll be the moderator for today's event. Our guest speaker is going to cover the fundamentals and more, so I'll jump right in. About our webinars. Our webinars take place monthly and cover a variety of relevant eDiscovery topics, trends, best practices, and strategies. We've got limited seating, so be sure to register early for the sessions that are of interest to you. If you have technical issues or questions, please email us at webinars@lexbe.com and we'll get those addressed right away. Our webinars are available online at lexbe.com for viewing via streaming video or downloadable as a PDF presentation or MP3 podcast. You'll find this webinar and a complete listing of other webinars at lexbe.com. To be notified of future live and on-demand events, please email us at webinars@lexbe.com or follow us on LinkedIn, where you'll find a lot of additional best practices videos and other content. So a little bit about us. We're based in Austin, Texas, and we've served almost 8,700 legal professionals with our cloud-based eDiscovery platform. We've been doing this for more than 16 years. We have the industry's most affordable and full-featured DIY cloud-based eDiscovery platform. We have the industry's fastest eDiscovery processing and document review platform. And so because of that speed, it helps you make sure that you have the maximum amount of time to build your best case. We deliver the industry's fastest return on investment per a study that was done by G2. We were also rated as the eDiscovery company that's the easiest to do business with. We have a full forensic lab staffed with Cellebrite certified forensic investigators who perform full and targeted forensic collections. And Cellebrite's the gold standard in forensic collection software. We also have a team of eDiscovery specialists who are ACED certified. And if you're just getting started with eDiscovery, you really should follow us on LinkedIn. We share a ton of educational eDiscovery content, including videos and guides that will help you get up to speed very quickly. Joining us today is Brian Doyle. Brian is an eDiscovery specialist at Lexbe, specializing in working with clients that handle eDiscovery and complex litigation that require a high level of precision and expertise. He has a JD from Mississippi College School of Law. He is also ACED certified, and his legal career spans over 20 years working as an attorney, case manager, and litigation paralegal with experience in both plaintiff and defense law firms in a variety of practice areas. Before I turn it over to Brian, I'm going to ask for your participation in a couple of polling questions to help set the stage for his presentation. Our first polling question is, have you experienced growth in electronically stored information, or ESI, in your cases over the past 5 years? Yes, no, or not sure. And while you're answering that, I'd like to thank you for participating in our polling questions today. All right, a couple more answers coming in, and I'll go ahead and close that poll. And our second polling question, do you view eDiscovery as an important capability that will help the growth of your firm or organization? All right, I will go ahead and close that poll. And without further ado, I'll turn it over to Brian Doyle. Brian?
Thank you, Jeff, for that introduction, and thanks to everyone for joining us. Remember when document review and document productions were limited to the paper documents contained in various banker's boxes in a client's warehouse or in a Redwell file in the client's office? In those days, there was a finite set of documents to review, identify, and produce. There were no worries about preserving metadata or identifying other sources of potentially responsive information. It was essentially unheard of. The data was what the data was. They were taken as face value. And if you needed to know when a document was created, who created it, or who modified the document and when, generally you would have to depose the document custodians or the individuals who created the documents. As data began to be digitized and stored in electronic databases for preservation and quick retrieval, an entirely new set of potentially relevant data called metadata was born. Metadata contains information such as the dates the documents were created, last modified, and saved, the author or person who saved or modified the document, and depending on the digitized data, metadata could contain additional information such as the document source, document size, the original title, and email header metadata, including to, from, CC, BCC, etc. Concurrently with digitization, data is being created and stored electronically, having never even existed in paper or hard copy form to begin with. With the digitization of data and the growth of the internet and social media, the amount of electronic data in existence has skyrocketed in the last 20 years. And the legal industry has been faced with the need to pivot away from the historical way of managing, reviewing, and producing relevant client documents and learn an entirely new way of managing what can most certainly be an overwhelming amount of client data. During today's webinar, we're going to take a look at how the amount of electronic information has increased over the past few years. And then we will look at the fundamentals for a basic understanding of data identification, preservation, and collection, how collected data is processed and culled, and the fundamentals of document review and production of the electronic data. All of the digital and electronically created data is referred to as electronically stored information, or ESI. As referenced in the U.S. Federal Rules of Civil Procedure, ESI is information that's stored electronically, regardless of the media, and regardless of whether or not it is in the original format in which it was created. So it's being stored, as opposed to being stored in hard copy or in paper, it's being stored electronically on some other media. Since the advent of the internet and social media, the creation of ESI has surged. And in December 2006, the Federal Rules of Civil Procedure were amended to address the discovery of electronically stored information. eDiscovery has now become the norm in the legal industry, and failure to understand how to preserve, collect, review, and produce the ESI could result in allegations of spoliation, which could lead to possible sanctions, including monetary sanctions, adverse inference instructions, or even default judgments and dismissals. This all in turn can lead to costly legal malpractice suits. So let's put this surge of ESI in perspective. In 2020, people created 1.7 megabytes of data every second of the day. I want you to think back for a second to those 3.5-inch floppy disks, the little small plastic ones that we used in the 90s to save all of our data on from our computers and our machines back then. They only held 1.44 megabytes of data. The entire 3.5-inch floppy only holds 1.44 megabytes of data. As of 2020, people were creating more data than that every single second of the day. Every day, approximately 306 billion emails are sent and 500 million tweets are made. And by the end of this year, approximately 70% of the world's gross domestic product will have undergone digitization. And by 2025, 200 plus zettabytes of data will be in cloud storage around the globe. So let's talk about the data in some more terms you might be familiar with. Pages. How much electronic data can fit in 1 gigabyte? Electronic text files, you can store approximately 678,000 pages within a gigabyte. More than 100,000 pages of emails, 65,000 pages of Microsoft Word files, approximately 17,500 pages of PowerPoint slide decks, and approximately 15,500 pages of images. That's a lot of data that can fit in just 1 gigabyte. If we converted all of this ESI to paper and printed it all out, how much paper would we have? Let's look at some comparisons. 1/2 a gigabyte, 500 megabytes of pages printed out would match the height of an average giraffe. That's between 14 and 19 feet of paper stacked. Doubling that, a gigabyte of printed paper would reach the height of an average telephone pole. So you're looking at a 35-foot stack of paper printed out if you're printing a 1 gigabyte size of data. 2 gigabytes are going to extend across an entire bowling lane. 10 gigabytes worth of paper documents would cover the length of a football field. 100 gigabytes would tower over the Burj Khalifa. That's the tallest skyscraper in the world at 2,722 feet. 500 gigabytes would reach the height of Mount Kilimanjaro. 1,000 gigabytes, 1 terabyte, would reach almost to the bottom of the Mariana Trench. That's over 36,000 feet, almost 7 miles of paper, 1 terabyte of data. That is a lot of data. As of 2020, there were 2.7 zettabytes of data in the world. To put this in perspective, there are 1,000 gigabytes in 1 terabyte and 1 billion terabytes in 1 zettabyte. So with 2.7 zettabytes of hard drive space, if you could convert this into hard drive space, you could store nearly 100 million years of high definition video on a 2.7 zettabyte hard drive. It's very clear ESI isn't going anywhere, and attorneys and other legal professionals who haphazardly engage in electronic discovery without a strong foundation of eDiscovery fundamentals are now facing increasing litigation costs to defend against motions to compel, spoliation allegations, and potential legal and ethical violations. So let's get into these eDiscovery fundamentals. My hope is that the information contained in this webinar will provide you with an understanding of the main elements of eDiscovery and serve as a guide for your own self-study so that you can become as competent in eDiscovery as you are in your specific area of the law. The Electronic Discovery Reference Model, or EDRM, is a flowchart that presents a conceptual view of the eDiscovery process and is designed as a catalyst for discussion and analysis rather than really a one-size-fits-all approach to eDiscovery. This is not necessarily a linear model that must be followed from left to right. And depending on the case, it may be necessary to engage in some, but not all of the steps in the diagram. This process is iterative in that you may repeat the same step numerous times, each time refining the approach as the facts of the case develop. The model presents the process as it moves in relation to the entire volume of available data, to the production and use at trial of the relevant data only. The first prong of the model, information governance, involves making sure that the entire universe of an organization's data, both electronic and paper, is in order and easily accessible and identifiable. Then as cases progress, the data is identified, preserved, and collected, and relevant data is then processed and reviewed for production. We're going to begin with the identification phase of the model and move through production. So what are the types of electronic data that may be subject to discovery during litigation? Essentially, there are 2 main types: custodial data, which is data that is within the possession, custody, or control of an individual or entity, and non-custodial data, which includes data stored on various data sources utilized by departments or business units of a producing party, but not necessarily maintained by a particular custodian. So let's look at some types of custodial data. Email data, whether they be sent emails, received emails, archived emails, emails that have been sorted into folders. Email data is quintessentially custodial data. If you're the owner of an email account, you maintain possession, custody, and control of those emails that are sent and received through that email account. Other types of custodial data include documents used in a normal office setting, such as Microsoft Word, Excel, PowerPoints, PDFs, typical office type documents, photographs or images, text messages, and any other type of data that is generated and maintained by a particular custodian, regardless of where that data may be located. Non-custodial data includes data stored on network locations, certain data management systems that may be in use with accounting, HR, or sales, for example. Multiple individuals generally have input into these types of non-custodial data sources, so they can't really be ascribed to a single custodian. Understanding these types of data will help you know the types of questions to ask your client's data representative so you can locate the relevant data to preserve it for the litigation. So we know the 2 main types of ESI, but where do we go to find the data? Most people automatically assume, and rightly so, that personal computers and emails may contain relevant data that may be subject to litigation. But what about other storage locations? Essentially, data storage falls into two locations, either personal storage on hardware devices or storage in the cloud. Obviously, computer hard drives and laptops would be the starting point for personal storage. This includes both business and personal machines if you use or if you've ever used your personal machine to conduct business. Again, it's crucial. Don't overlook your personal computer or laptop, especially in the post-pandemic world. Over 48 million people reported working from home during the pandemic in 2020. If these folks use their home computers or personal email addresses to conduct business even one time, there's likely to be relevant data on those home computers. Data also stored on handheld devices such as cell phones or PDAs, like a Palm or a BlackBerry, can also be relevant to litigation and must be identified and preserved if necessary. This includes text messages and chat messages. Network servers can house both custodial and non-custodial data. Companies often have multiple servers that can contain relevant data. And then we mentioned the records management systems that are maintained by human resources, accounting, marketing, sales. Often those programs are going to contain data relevant to pending litigation. But then there may be some more obscure sources of data you may not really have thought about that could be subject to discovery. For example, data stored on wearable devices such as an Apple Watch or Fitbit and the like can be subject to discovery. So picture a personal injury claim where the plaintiff claims to be unable to exercise, walk, or perform certain tasks due to an injury. Yet the plaintiff's Fitbit has recording them taking 1,000 steps in a day or walking half a mile. Certain wearable devices now monitor and maintain records of heart rate, blood pressure, and even how often a person sits, stands, or moves about. If you're defending against this personal injury claim, you're going to want the data from that wearable device. Consider virtual reality devices and gaming consoles. These devices often collect extensive biometric data on their users, which can identify the users and infer additional information about them. Chat logs, audio files, and videos of interactions in the virtual reality environment can all be subject to discovery and serve as evidence in lawsuits. So we've identified the relevant data on hardware devices. So let's see where additional relevant data may exist in the cloud. Cloud-based storage locations include Google Drive, OneDrive, Dropbox, Box, iCloud, Amazon Web Services, iDrive, and the like. These locations are a dime a dozen. Often the data stored in the cloud may be duplicative of data that's stored on hardware devices, but it is becoming increasingly more common to store electronic data directly in the cloud, bypassing any hardware storage. Photos and documents saved to Google Drive, for example, won't necessarily be on your local hard drive unless you've downloaded them. They will exist solely in the cloud for retrieval. Internet-based email, such as Gmail, AOL, iCloud Mail, is all generated and stored and archived in the cloud. Social media may also contain relevant information and must be considered for preservation and collection. Facebook, Instagram, TikTok, WhatsApp, Twitter, all of these social media platforms could contain relevant information, even if the user deletes comments or videos. If you believe your client posted, said, or recorded anything relevant to the suit on social media, you're definitely going to want to check out their social media account to determine if there is any relevant data out there. And then you have what's known as the Internet of Things, or in the eDiscovery industry, the IoT. Do you have an Alexa in your home? Have you got a smart TV or a refrigerator with one of those smart screens? Alexa records and stores data based on daily interactions with the user, just as Siri, Google Assistant, and Cortana do. The Internet of Things is a relatively new source of potentially relevant data. Generally, the Internet of Things is a network of physical objects or things that contain sensors, software, and other technologies that are designed for the purpose of connecting and exchanging data with other devices and systems over the internet. So now we know the two main types of electronic data and where the data may be stored. The next step is to take steps to preserve the data for the pendency of the litigation. So what is data preservation? Data preservation is the process of retaining documents and electronically stored information, including document metadata, for legal purposes, and includes a suspension of the normal document destruction policies and procedures. So when does the duty to preserve the data arise? How do you know when you need to preserve the data? The duty to preserve electronically stored information arises when a party reasonably anticipates litigation. Now, various courts have examined what reasonably anticipates means. Obviously, the receipt of a formal complaint, a subpoena, or a regulatory notice will trigger the duty to preserve. But the duty could arise simply on the basis of an oral or written threat of litigation. If a party orally threatens to sue your client, then depending on the circumstances, the company may be required to begin the identification and preservation of relevant data before that lawsuit is even filed. Also, company incidents such as major accidents or employee injuries while on the job may trigger the duty to preserve the relevant ESI, especially if litigation such as personal injury, workers' compensation, or products liability suit is expected. This may be before a suit's even threatened, much less filed. Courts have also considered a company's litigation history in determining when the duty of preservation arises. If similar incidents in the past have resulted in lawsuits or claims being filed against the company, then there may be an ongoing duty of preservation. Many oil and gas companies, for example, are constantly defending against environmental lawsuits. In certain situations, those companies may be under an ongoing and indefinite duty to preserve data for current and future litigation. So now that we have a general idea of what custodians have the relevant data and where the data resides, how do you act? How does a company or your client act on this duty to preserve the data? The industry standard is the issuance of a legal hold plan. A legal hold is a communication issued as a result of current or reasonably anticipated litigation, audit, government investigation, or other such matter that suspends the normal disposition or processing of the records. The legal holds can encompass procedures that affect data that is both accessible and data that is not reasonably accessible. And this specific communication to the business or IT organizations and custodians can also be called a hold, a preservation order, a suspension order, freeze notice, hold order, litigation hold, or hold notice. Most companies have a document retention plan or a document destruction policy in place whereby they back up, archive, and eventually dispose of data after a period of specified time, normally after a few years. The legal hold plan will suspend that destruction policy throughout the pendency of the litigation to ensure that no potentially relevant data is lost or destroyed. Although it's not required by law that litigation hold notices be sent, it behooves you to do so for a number of reasons. First, litigation hold notice can set the agenda for the Rule 26F conference. It gives you the groundwork for discussions involving the issues regarding retaining data from certain sources or data that may not be reasonably accessible. And the notices should be sent to the custodians involved in the lawsuit at hand, as well as to opposing counsel or third parties that are or may become involved in the suit, or who possess potentially relevant information. Effective and defensible legal hold plans should contain the following elements: a statement of the complaint, dispute, or investigation that's given rise to the duty to preserve. The notice should provide enough information about the facts of the case that the recipients will be able to determine what information is considered relevant and should be preserved. So include a list of the key individuals or custodians, relevant dates, major events, locations, products at issue, or any other pertinent information you have about the case. And to avoid the destruction of potentially relevant materials, it's best to provide as much detail about the case as possible. Your legal hold plan should be in writing. Oral holds are possible, but they're rarely defensible and difficult to track. So just make sure your legal hold plan is in writing so it can be repeated if necessary and is certainly defensible. Custodians should be provided clear examples of the potential locations of ESI. They may not think about wearable devices, Alexa, or the like, so the notice must clearly set forth all types of data that should be retained, including ESI, hard copy documents, software, hardware, and the like. It is important to list examples of the various data types that fall within each of these categories, such as email servers, mobile devices, CDs, DVDs, flash drives, external hard drives, voicemails, databases, backup tapes, file servers, and so on and so forth. The legal whole must be addressed to specific individuals, and it must be distributed personally, and it must provide clear instructions for how to accomplish and implement the legal hold. The plan needs to reference a point of contact for any questions about compliance with the hold, because there's definitely going to be questions, and there should definitely be someone the recipient can go to have those questions answered. Legal hold should require a confirmation of receipt. If you send it by email, read receipt should be enabled. If delivered personally, subjects to the hold should sign something indicating that they have received the notice, or otherwise attest to the fact that they have received the notice. And then the attorneys and company personnel will want to set up interviews with the main recipients of the hold to explain exactly what's required, answer any questions that they may have. Since litigation can often last for years, there should be periodic reminders sent to the hold recipients that everyone is still subject to the litigation hold. And finally, once the litigation is over, recipients of the legal hold should be notified of their release from the hold. If data preservation attempts are ever questioned, companies should have reliable means of tracking legal holds to defend the preservation process. So what happens if you fail to preserve relevant and potentially responsive ESI? First, there could be a loss of or a failure to identify potentially relevant information. If the ESI is sloppily preserved, you may miss that one document that completely turns the tables of the litigation in your favor. That smoking gun document may never be found. You also risk claims for spoliation and motions for sanctions, which can result in monetary awards, adverse inference instructions, a limitation of claims or defenses, default judgments, and even dismissals of the suit, especially if you're facing opposing counsel who has a strong understanding of ESI and eDiscovery preservation. You could be engaged in discovery about the discovery for months, which adds additional time and expense to an already expensive and lengthy litigation. So now that we've identified the types of ESI, found where it is stored, and have issued the legal hold to preserve the data, it's time to collect it, or in legalese, it's time to harvest the data. Data harvesting is the process of retrieving or collecting electronically stored information from any media. An eDiscovery vendor or specialist harvests ESI from computer hard drives, file servers, CDs, backup tapes, portable devices, and other sources for processing and loading to storage media or to a database management system or other eDiscovery tool. So what exactly do you collect? You've preserved all of its data, but do you have to collect all of it? Do you have to collect everything that has been preserved? Absolutely not. By the time the actual collection stage of the litigation rolls around, you will definitely know the claims and defenses of the lawsuit. The complaint will have been filed. It most likely will have been answered. And you will also have gone through the preservation process to identify and preserve the relevant information associated with those claims. So the collection can target just what you believe to be the relevant data, the relevant information based on the claims or defenses in the lawsuit. So out of the preserved data, depending on the claims and defenses, you may want to collect individual employee files, including email accounts, again, both personal and business, if the personal account is also used for business purposes, and data from workstations and hard drives. And again, a reminder to remember the personal laptops and personal machines. There may be relevant department or group files and information stored in the cloud and various management databases that need to be collected for review. And don't forget about the backup media. Files backed up to archive servers or tapes may very well have relevant information that needs to be collected and reviewed. At this point, you should have done interviews with the data custodians to determine exactly where all of the relevant data resides. Executing a collection of all preserved data could reach astronomical expense. So trust the company individuals that are familiar with the data to guide you to where the data to be collected actually resides within the company. So now we know what to collect. When do we collect it? Well, the first most easily accessible data and the least expensive to collect is active data. Active data is data that can generally be accessed by opening up File or Windows Explorer on a laptop or a desktop. It's stored on a hard drive or a server and is immediately available for download and collection. Active email accounts, for example, are the quintessential quintessential active data. After the active data has been collected and is complete, then turn your focus to the archive data. The archive data is the data that's been backed up and likely removed from the active servers and has been copied to removable hard drives or other storage media. This is always less accessible than the active data. And so it's generally going to require the intervention of IT or other network personnel within the organization to retrieve or collect the backup data. Forensic data should be the third type you focus on, which includes deleted, damaged, or hidden files that are generally more difficult to access and aren't visible by the user. They typically are going to require the expertise of a forensic specialist or a forensic examiner to retrieve that type of data. Finally, there is legacy data, or data that was created using systems or applications that are no longer in use or obsolete. Your Rule 26 conference or ESI order, an agreement with opposing counsel, should govern whether any relevant data may apply or may reside in legacy systems. And it should address the time and cost to retrieve and process that data into a usable form, and address who should bear the burden of the cost to retrieve the data and provide it in that usable form. There are various methods of collection. Self-collection can be undertaken if the custodian is able to collect and export the data without changing or degrading the qualities of the data, including the metadata. Typically, self-collection is reserved for small cases with few claims, limited budgets, and small sets of data that can be easily pulled from a few locations, such as email accounts and computers. Care should be taken to make sure that any self-collection done by the individual does not alter the data in any way. Corporate IT departments often undertake the collection of certain data. They should be familiar with all of the systems in use within the organization and should know how to collect and export the data from these systems while maintaining the data integrity. And finally, certain data requires the expertise of a forensics examiner for defensible collection. Remember, we referenced the deleted and corrupt data. If a portion of a drive has been deleted or certain data is corrupt, a forensic specialist will be required to attempt to recover or repair that data. The needs of the case itself are going to dictate which collection method should be undertaken. Once you're winding down the collection process, in order to effectively defend the collection, you will need to validate that all of the responsive ESI has been collected and validate the authenticity of the collection. So to validate whether the responsive ESI has been collected, ask yourself, has the data been collected from all of the targeted custodians? Has the collection method been documented? And is it repeatable if additional evidence is needed? Have post-collection custodian interviews been done to confirm that a full and complete collection has been accomplished? And during the collection of the data, did you find anything new you weren't expecting? You're also going to want to validate the authenticity of the collection. This is typically done through a combination of a chain of custody log and sworn testimony from the person who performed the collection. Validation is a necessary step to review your collection process for completeness and be able to defend the collection if called upon to do so by the court. So now that we have collected the relevant data, what do we do with it? A lot of the data may be in raw form, or it may be in a format that doesn't lend itself to an easy review. The total volume of the data may also seem insurmountable. So the next step is to process and cull the data to a smaller set of relevant data for review for responsiveness, privilege, issues, and production. Engaging an ESI vendor is the best way to process the data for production. What exactly does processing mean? In the Lexbe eDiscovery platform, data processing includes several automated steps and then some additional optional post-upload processing steps that you can take to organize and present your data for review in a normalized and usable fashion. Processing that occurs automatically when data is uploaded includes conversion of the data to a normalized format, which is usually a PDF. It generates a PDF that allows redaction, annotation, and the like on the documents. Automatic processing is also going to include MD5 hash assignment and the assignment of placeholder files for files that aren't supported by the platform or for files that fail to generate a normalized PDF document. Automatic processing also includes expansion or unzipping of zip, RAR, inbox, and PST files, and includes the extraction of email attachments and the creation of email family relationships for efficiency in review in the platform. Relevant custodian information can be assigned during upload, and relevant metadata is extracted and populated into built-in data fields in the platform for searching and for filtering. Automatic processing also includes native text extraction and OCR to provide for greater accuracy in search results, and the creation of an index, which creates a searchable text index of the text and metadata associated with the documents. In addition to the automated processing that generally happens automatically upon upload of data, there are post-upload processing steps that you may also take. DNIST, deduplication, near duplication, and email threading. Those are 4 ways of culling the data, and we'll look at those in a bit more detail in just a minute. The assignment of case keywords for persistent highlighting across all the data is a post-upload processing step that you can take. You can choose to have important words in your case be highlighted in the text tabs of your documents so that you will be able to see quickly where your key terms are within those documents. Transcription of certain types of recorded data, image detection, sentiment detection, and document language detection and translation, and search term reports of keywords and auto redaction are all post-processing steps that can be undertaken to reduce the number of documents that you have to review. We've mentioned metadata several times now, so let's take a look at what exactly metadata is. Simply put, metadata is the information about the data being processed. This includes things like the title of the file itself, but it can extend far beyond to include other attributes of the file, such as who authored it, when it was created, or when it was last modified. As metadata is extracted from the data during the automated processing, that information is populated into built-in metadata fields in the review platform so that you can filter on those fields and conduct review based on the information within those metadata fields. Most eDiscovery platforms provide load files as part of a production job output, and those load files contain data from certain built-in standard metadata fields. eDiscovery metadata generally is file metadata that contains timestamp information, edits, revisions, author, date and time the file was last modified or saved, and other user-supplied data that can be altered. The information is generally internal to the document itself and is not generally visible to the average user. So once the data has been processed by an eDiscovery platform, it's time to cull the data down into a manageable subset of data. There are several culling methods available in most eDiscovery platforms. DNIST is a process that reduces documents for review by identifying and deleting file types that are highly unlikely to have evidentiary value. During the DNIST process, all ESI uploaded to an eDiscovery platform is compared against the National Institute of Standards and Technology, or NIST, their software library, and it identifies and deletes files matching those on the list that are unlikely to contain relevant information. Deduplication identifies files as exact duplicates based on their MD5 hash value, or in the case of native emails, email header information. And these files can be deleted or suppressed during a document review. The near duplication culling process identifies documents with a 50% or greater overlap in textual content. Post-processing near duplicates can be reviewed in groups to streamline review of the data. And then finally, email threading groups email chains or threads together based on the email metadata. So threads can be reviewed within their thread group, and in Lexbe in the threading visualizer, where emails can be selected for coding, viewing, and comparing. By far, the most common method of data culling is via keyword searches. And there are a few things to keep in mind when developing and negotiating your search terms. First, for your keyword searches, develop a keyword strategy. Take your request for production or your subpoena ducis tecum and translate those demands into a keyword search strategy. Construct your queries to return documents that are likely to be responsive, confidential, and/or privileged, and negotiate those search terms with the opposing parties so that everybody can be on the same page with regard to the terms that are used to locate potentially relevant data. Include industry jargon in your search. Be sure to seek out company subculture specific terms and abbreviations or acronyms that you may not be familiar with. You have the potential of missing some documents if you're not familiar with some of the industry jargon that you may need to use to conduct your search terms. Ask key custodians and case participants about their ESI. Use their insights and their suggested terminology to find obscure key documents. And then be sure to include misspellings or spelling variations in your keyword searches, or use the fuzzy search settings or Boolean limiters in your search string to account for email addresses or other words that may contain typos. Now that you've processed and culled your data into the final relevant universe of documents, it's time to start reviewing and coding the documents in preparation for production. Before you dive in and start reviewing documents, you will want to develop a plan for review so as to ensure both efficiency and consistency among the people who will be reviewing your documents. If there are going to be only 1 or 2 people who are doing the review, then the review plan could differ significantly from the review plan for a team of 30 outsourced reviewers. There are 3 general categories of document review: linear review, keyword search, and technology-assisted review. And there are advantages and disadvantages associated with each type of review. You just need to decide at the outset how you want to approach your document review and then be consistent with it. Think about a linear review as comparable to sitting down in front of a banker's box and reviewing the contents of the box, document by document, from front to back. There's no rhyme and reason to the organization of the data other than the filing system that was set up when the documents were boxed up. Linear review of ESI works much the same way. You start at the beginning with the first document and review straight through from front to back with no apparent association between one document and another. Linear review works best in cases with very few documents or in special cases where an eyeballs on every document approach is necessary. Arguably, the most widely utilized method of review is the keyword search that may also contain a linear review component. Document review manager overseeing a multi-person review team or the small handful of attorneys conducting their own review of the documents would theoretically come up with a list of keywords to search through the data set. If you performed keyword searches during the culling stage, then you have your list of keywords ready. You now can just narrow that list down, focus on the most important ones, and then run the searches over the relevant documents that you have identified to isolate for review smaller groups of data based just on those search terms. The reviewers can then conduct a linear review of the smaller groups of documents. Typically, the keyword search review is done in larger cases with high document counts and short production deadlines and limited review budgets. Technology-assisted review, or TAR, is a third type of review that relies on a combination of artificial intelligence and algorithm training, often used in huge cases with hundreds of thousands or even millions of documents. Reviewers train the algorithm by coding a seed set of documents for responsiveness, so the algorithm can then code the rest of the data. So let's take a quick look at the advantages and disadvantages of each review type. Some of the advantages for a linear review: obviously somebody reads all the documents. So every single document in a linear review set is going to get a set of eyes put on that document. The person doing the linear review can simultaneously code for responsiveness, privilege, and issues, and can code hot docs and potential deposition exhibits as you go through and review the documents. Some of the disadvantages, of course, are it is the most time-consuming method because you have to read every document and you're putting your eyes on every document. So the more documents you have, the longer it could take to conduct a linear review. And oftentimes firms outsource linear reviews to junior associates or maybe contract attorneys who may not necessarily be as familiar with the subject matter of the litigation as in-house attorneys are. So there is a potential for high error rates among reviewers and inconsistency among a review. Some of the advantages of a keyword search is it takes much less time than a linear review. And so manual review errors are minimized. And you can negotiate those keywords with opposing counsel, as we've discussed. Plus, you can construct sophisticated Boolean logic to try to drill down to that smoking gun document that you're looking for. But keyword searches are only as good as the keywords themselves. But you can sample those keywords, test them, and improve them. If you don't include all of the right keywords, then it can lead to an under-inclusive production. Or if your keywords are too broad, then you may end up doing a data dump on opposing counsel and producing data that is way over-inclusive. Plus, with a keyword search, somebody still needs to go through and review all of the documents for deposition preparation or for trial and mark those accordingly. Some of the advantages of TAR is that it's the fastest review method. It can find documents that keyword searching misses, and TAR is becoming more accepted by judges in different jurisdictions. But some of the disadvantages of TAR is that the accuracy of the algorithm is based on the quality of training the seed sets. There's also an increased cost for processing. A TAR is not cheap, but typically the costs associated with a technology-assisted review are offset by the reduced time it takes to perform a linear review of the documents. TAR does not code for privilege. TAR only codes for responsiveness. So somebody will still need to go through all of the documents that are coded as responsive and non-responsive and review those documents again to determine if any of the documents should be designated as privileged. So now that we've reviewed the documents, it's time to produce them. Let's look at the three main types of eDiscovery document productions. The most basic form of a document production is a native production. With a native production, documents are not converted in any way, but are produced to appear exactly as they did at the time the document was created. A native Word document, for example, will open and behave in the recipient's Microsoft Word program exactly as it does for the producing part. Excel files are produced natively, maintaining the filters, pivot tables, formulas, etc., as exists in the original. If you take these native documents and convert them to PDF, and then individually Bates number the pages or mark them with a confidentiality designation, you have what's called an imaged production. An example of this that is common in law firms would be sending a banker's box full of paper documents to an outside vendor to scan to PDF, and then Bates label or mark those PDFs confidential as necessary. And then finally, the standard most accepted and most defensible type of eDiscovery document production is the full eDiscovery production with load files. You may have heard this referred to as a concordance type production, which is a throwback to the old concordance document review system. This type of production utilizes an eDiscovery platform or an eDiscovery processing tool to generate Bates stamped images with confidentiality designations and redactions if desired. It includes full extracted text and full extracted metadata fields, along with load files that are designed to load the metadata and the documents into the tool being used by the receiving party to host and review the production. As with the different review types, there are also advantages and disadvantages associated with each type of production. With a native production, obviously some of the advantages include no time or expense involved in converting the documents. You just give the opposing side the documents and they're presented the same way as they were when they were created. Some of the downside of producing natively are obviously the potential for alteration. It's easy for someone to get a native document and accidentally or intentionally alter that document. There's no ability to Bates number or otherwise mark individual pages in a native production. Bates numbering can only be done on a file basis, not on a page basis. And native productions contain the full set of embedded metadata, which could include privileged or otherwise confidential information that may need to be addressed before these documents are produced. And native productions, by the very nature of the fact that they can't be Bates numbered, aren't amenable really for use as deposition or trial exhibits. Some of the advantages of an image production is it is more difficult to alter image produced documents. Imaged productions have distinct pagination that allow for Bates numbering and confidentiality designations, therefore making image productions easier to use as deposition or trial exhibits. But the costs associated with converting documents from their native format to an imaged PDF need to be discussed with your client. And sometimes image productions are a time-consuming process that require additional days before the production due date, solely converted to conversion of the documents. Converting native data to image data loses metadata. So there is a possible loss of relevant and useful information in that metadata. And oftentimes, image production can't are not considered reasonably usable as required by Federal Rule of Civil Procedure 34. And think of this like an Excel spreadsheet. If you've seen an Excel spreadsheet that has several rows and several columns and maybe built-in pivot tables or formulas, those types of documents don't really lend themselves to an easy review in PDF format. And as such, they're not reasonably usable. So image productions, you have to take into consideration that with an imaged production, you may also need to produce native versions of documents so that the data you're producing will be reasonably usable under Federal Rule 34. The advantages for an ESI production are that it provides both image and native files. It provides extracted text for greater searchability, Responsive metadata is retained in load files. Any privileged documents are automatically ascribed to a privilege log. And ESI productions comply with most ESI orders and are accepted by judges in almost all jurisdictions. Pretty much there aren't a lot of disadvantages associated with an ESI production other than the hosting costs with an eDiscovery platform. And you may encounter opposing counsel who doesn't have a high level of knowledge of eDiscovery, and they may wonder why you're producing an ESI type production to them and what are they supposed to do with the data. So those are really the disadvantages of an ESI production. So what are some takeaways? The advent and recent explosion of electronically stored information has changed forever the way that discovery is managed in litigation. eDiscovery is a minefield for legal malpractice, and attorneys have an ethical obligation to become experts in eDiscovery and in the eDiscovery processing tools to avoid potential costly motion practice, claims of spoliation leading to sanctions, default judgments, or even dismissals, all leaving open the door for legal malpractice claims. It is absolutely essential at the outset of litigation that both the attorneys and the litigants know what kind of ESI exists, where it is stored, and how to identify and access it. Take defensible steps to preserve potentially relevant data so as to avoid accidental or intentional destruction or spoliation. Collect relevant data in a legally defensible way that maintains the integrity of the data. Authenticate that all relevant data has been collected, and interview or depose custodians to ensure that nothing has been overlooked. Process and review the data for responsiveness, privilege, and confidentiality in the most efficient and cost-effective way based on the needs and budget of the pending litigation, and produce responsive non-privileged data in a way that is both usable by the opposing party, compliant with the local rules, and defensible in the event of subsequent discovery motions. I want to thank everyone for joining us for the webinar today. And with that, I want to thank everyone for your attention during today's webinar, and I will turn it back over to Jeff.
Thanks, Brian. That was a great presentation. Now I'm going to briefly walk you through how Lexbe helps law firms and enterprises handle document-intensive matters and streamline the eDiscovery process. At Lexbe, we provide comprehensive remote and on-site forensic collections that are fully defensible. We utilize industry-leading tools like Celebrite and Magnet. We can help you identify and collect the documents you need to build your case. And we handle a very wide range of devices and account types, as you can see on this partial list. Now I'd like to ask our next polling question. Do you have a forensic collection project, and would you like a complimentary consult? All right, I'll go ahead and close that poll. With Lexbe's eDiscovery platform hosted at Amazon Web Services, you get on-demand capabilities that scale to address the needs of your case. With Lexbe's cloud infrastructure, you can get from document ingestion to review faster and get your productions out the door faster. All of your remote or mobile connected employees can access the Lexbe eDiscovery platform via a web browser. It works great on Macs, PCs, iPhones, and Android devices. And here I wanted to point out that Lexbe is a single end-to-end eDiscovery platform, which simplifies the process. So you've got everything you need in a single solution. Unlike many eDiscovery providers, you don't have to move your data from one solution to another. Lexbe has fully integrated document processing, document review, analytics, case timelining. We have artificial intelligence algorithms that I'll touch on here in a minute, and production capabilities. Keeping your data in an end-to-end eDiscovery platform like Lexbe helps eliminate the risk of errors from moving data between platforms and reduces the cost. The other thing is you can do it yourself, and you don't have to use expensive eDiscovery project managers, to handle the process of like moving data from one platform to another. Keeping it all in one, you can do it yourself, reduce your costs, and it makes it a lot simpler. Lexbe utilizes artificial intelligence and machine learning algorithms for several use cases. This includes audio and video file transcription, language translation, sentiment analysis so you can quickly categorize emails with a positive or negative tone, cognitive image recognition so you can quickly sort photos based upon the content of those photos, entity identification, and more. These algorithms help you handle document-intensive matters with limited staff. Now I'm going to talk to you about eDiscovery pricing. The purpose of eDiscovery technology should be to improve your document review capabilities while driving efficiencies in both time and cost. Unfortunately, there's still a lot of eDiscovery providers that don't pass on the cost savings that technology affords. We host Lexbe in the Amazon Web Services cloud. This means our processing, storage, and networking capabilities are not only highly advanced, but they're also incredibly cost-effective, and we pass the savings on to customers. Here's an example of how we compare to a relativity reseller. We engineered and developed our platform more than 16 years ago and continue to innovate and improve with each new release. And in this comparison, you'll see that the relativity reseller charges $30 per gig for data ingestion, which is processing. Our highly efficient processing servers enable us to offer this for free. While the concept of promotion might sound good, this is usually a cost that's associated with moving data from one platform to another. And as I mentioned, the Lexbe eDiscovery platform is an end-to-end platform and doesn't require that you move the data. And not only does this save you $125 per gig in this case, but it also helps eliminate data handling errors. We also don't charge user fees, so you can have as many users as you need at no additional cost. We also have 7 different user permission levels to help keep your data secure. We don't nickel and dime you either with what's called OCR or electronic endorsement fees per page. We also have highly advanced analytics integrated into the platform at no additional cost. And we're able to deliver savings on the hosting costs too. So regardless of if your case is small or document intensive, I'm confident you'll find that Lexbe delivers the industry's best return on investment. Now, here are a couple of examples that I wanted to share with you of the quality of our service that we've delivered to more than 8,665 legal professionals. Here, Paige Tackett with Thompson Co. highlights the ease of use and speed of Lexbe. And here, David Jones of Logan Lowry had a very successful outcome with his case by using Lexbe. And again, they had a very limited staff. They were up against AmLaw competition in terms of the opposition. And with that, I'll ask our last polling question, and that is, would you like a demo of the Lexbe eDiscovery platform? While you're answering that, I'll let you know we'll be making the following available to webinar attendees today: a recorded streaming version, an MP3 podcast, as well as a PDF. Please let us know if you have any questions or comments about this webinar or suggestions for future topics. This webinar is part of the Lexbe eDiscovery webinar series. For notices of future live and on-demand webinars as part of this series, please email us at webinars@lexbe.com or follow us on LinkedIn. And thanks for answering that polling question. And with that, I'd like to thank Brian for presenting today. I thought it was a great presentation, and I'd like to thank you for attending. Watch your inbox for an invite to our next webinar on best practices in eDiscovery. Take care.